Hi, I'm David Yurkofsky, immigration attorney, talking now about E-1 treaty traders and E-2 treaty investors. For starters, you need to make sure your country is on the list. There are two different lists. They're similar, one for the E-1 treaty traders and one for the E-2 treaty investors. These visas are designed to help friendly countries who have signed a treaty with the United States do business with the United States, whether it's people who are investing in a business in the United States or people who are trading with the United States. Let's focus first on investing in the United States. First, the company needs to qualify. That means the company needs to be majority owned by people who are from your country, assuming your country is on that list of countries. The investment needs to be substantial. And that's a pretty general word, but it basically means that it's got to be an attempt to create an enterprise that's going to grow and perhaps thrive in the United States. What's interesting here is that this does not have to be an established company that has affiliates and branches in other countries or even your own country. You just have to have a company that you open in the United States. It could be a brand new company as long as at least over 50%, 50.1% is owned by people from your country, then the company can qualify for E-2 treaty investor status. Second, there must be investments made in that company. They can be new investments or they could have been an established record of investments over the past several years. These investments have to be investments that are substantial, enough to grow the business. If you're talking about a new company, you even have to include a 5-year business plan in your E-2 application to show how you're going to market, how you're going to sell, how many people you're going to hire, what kind of office space you're going to rent. Generally speaking, these days, the kind of case that's going to win is one that has an investment of at least $100,000 to cover all the expenses and salaries for the first year. So, if the majority of the company is owned by people from your country, that is that at least 50.1% of the stock is owned by people from your country, that it's a substantial investment, that it's an investment designed to make it grow, then there's a good chance the company will qualify for E-2 status. What about you? What job can you do with an E-2 visa? For you to qualify, you don't need a college degree. You don't need to have any prior experience working in that country like an L1 that needs to have at least 1 year. All you need to be is an executive or manager who's coming to run the company, or someone with specialized knowledge or experience that's required to run the company. And you yourself can qualify for E-2 status. In contrast to the E-2, the E-1 is not about money. It's not about investing money and growing the business. It's about trade, and lots of it. The more trade you can show, the better. Planned transactions of upcoming trade. And what's a little difficult about this one is you have to prove that the majority of the trade is going to be between the U.S. entity that's sponsoring you to be an executive or specialist or business manager and the country you're from. So if more trade is going on with a country other than the United States, that disqualifies the company and you from having an E-1 visa. When we talk about trade, we're talking about importing and exporting. We're not talking about one shipment. We're talking about a series of shipments that have already taken place, or a series of shipments that are going to be taking place, that are planned for the future. A trade that's going to grow and thrive. Once again, my name is David Yurkofsky, immigration attorney. I've just provided you with an overall summary of the E-1, E-2 visa. If you'd like to seriously pursue this, then you really do need specific legal advice. I'd be delighted to help you with that. My contact information is available on my website. Thank you.